Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. Another episode of Military Justice Today. I'm Matt Starosiak, of course, sitting in the podcast studio with Robert Capovilla. Hey, Rob, what's happening?
Hey, Matt, how you doing?
I'm doing great. Nice to see you today.
Good to see you, too.
Another episode of Military Justice Today. What do you think about that?
I'm pumped to be here. I love coming into the podcast studio and talking about issues that impact our service members and our veterans. It's a wonderful privilege to get to do this show.
It is. It's something a little bit different, something a little bit fun, and we do enjoy it quite a bit.
I never... To be honest, when we started doing this show, I never would have imagined that we would have created the number of followers that we have. Our shows are routinely getting looked at by anywhere from 5,000 to 10,000 people per episode. And I'm pretty sure when we started this podcast, it was my wife, Mickey's wife, maybe your family, and maybe the gal who answers our phones. And that was about it. So it's been pretty cool to see some of our episodes shoot north of 10,000 listeners.
Weren't you recognized in the southern part of the U.S. recently as being a celebrity or some sorts?
Yeah. So that's true. I was at
might be a little bit of an exaggeration, but
not a celebrity, but sometimes when I travel to military towns, folks recognize the name, and that's always a great honor. And I was able to buy a round of beers for a bunch of sailors and Marines in a particular location recently. And that's a great perk. It's a real credit to our veterans and our service members and to you and to the folks here at the studio that put this podcast on. And it's just great fun to come in here and do this. And I hope we get to do it for many, many, many years to come.
I agree. 100% agreement. It's not very often you and I agree 100%, but I agree with you 100% on that.
That's true.
Let's get into the thick of it on today's topic, and we're going to talk about medical professionals in the armed forces and those who run into maybe a smattering of different kinds of issues. I want to kind of get your opinion on some things. We'll talk about maybe some of your recent cases that you've had on this exact topic. And I think it's fascinating. I've done work with several law firms that do this kind of work in the civilian side where they're representing doctors, nurses, chiropractors in front of like the Georgia Composite Medical Board. So I'll try to feed you some questions along the way. But I guess for just foundational purposes, what we're talking about here are medical professionals who work for the military, one of the branches, and they run into some kind of problem which has potentially serious impact on their career. It seems like the flavor of these, Rob, and correct me if I'm wrong, tend to be maybe a handful, which are impairment. You know, they show up at the job impaired or under the influence. They have an improper relationship with a patient. They might be skimming drugs or accused of skimming drugs from the system, or they make a serious mistake. And those are the things that I've seen, at least on the civilian side, most often. Would you agree with those types of issues? Can you think of any others that might apply as well? But are those the kind of things you're talking about?
Yeah. So first, let's set kind of the baseline subject matter, right? Because you're right. We're here today to talk about medical professionals, in particular medical professionals that serve in the military. And as all of those professionals know, or as any judge advocate who's worked as a judge advocate for a hospital, the way that I did when I was at Fort Benning, now Fort Moore, you learn a couple things that are unique about medical professionals in the military and what their rights are and what their licenses are and all these kind of things. So it's important to note, Matt, that when we're talking about these medical professionals, not only do they have to be licensed in the state where they are to practice the type of medicine they practice, like attorneys, right? But in addition to being licensed by a state, military doctors, military dentists, and other healthcare providers employed at military hospitals and clinics must also maintain what they call privileges with the privileging authority. And generally what we're talking about there is the authority to grant, suspend, and revoke privileges. That usually rests with the commanding officer of the military hospital or the military treatment facility.
So you don't just show up and interview for a job and all of a sudden you start practicing medicine at your local military hospital.
Correct.
You have to be granted privileges to do that.
Privileges, that's right. And then so what that means is that if allegations are made that the provider engaged, to your point, in misconduct or is impaired, the privileging authority must determine whether or not a full investigation is warranted. So, yes, you are right. A lot of the stuff comes down to, we've seen medical cases over the years where, in particular, pharmacists or folks who have access to medications start to have an addiction issue. I've seen a lot of sexual harassment issues, a lot of standard of care issues, right? Folks are treating our service members. Allegations are made that they're not doing it up to the standard of care. And then there's also just kind of the broad general misconduct, right? And in a military sense, that can be a number of different things. So what happens is allegations are made against the military provider. And typically when those allegations are made, there's going to be a preliminary inquiry that almost always is going to turn into a formal investigation, which is called the quality assurance investigation. And in fact, the rules say that the rules favor a full quality assurance investigation following any allegation of misconduct, incompetence, or impairment that is not determined to be baseless through that preliminary inquiry. So that's a little bit about the background. Allegation made, quality assurance investigation gets kicked off.
Now, something that I saw when I was kind of prepping for the show, and I don't know that you'll have a full and complete answer on this, but during that investigation that's launched, they're not just limited. The investigation is not just limited to that one particular issue. It sounded to me, at least in the literature that I saw, was that they could also look at other things or maybe a pattern of conduct as they're doing that investigation. Is that your understanding of it or not so much?
Yeah, so that is correct. And that doesn't make it all that different than the Army's version of a 15-6 investigation or the Air Force's version of a CI, a command investigation. So allegations are made, and an investigating officer will be appointed. And then, yes, I mean, the reg does give some latitude to the privileging authority and to the investigating officer to do broad investigations. And what oftentimes can happen is during the course of an appointed investigation, more misconduct comes up. And I've dealt with that personally with some of our clients. So, yeah, Matt, there's not, essentially those investigations can turn into investigations into patterns of misconduct or misconduct that was otherwise not known at the time of the appointment. And there's some things the privileging authority's got to do to protect him or herself if that happens. But generally speaking, yeah, they're able to investigate these things.
All right. So question, obviously, anytime an investigation is launched, we talk about it on the podcast a lot about winning a case or kind of getting your footing solid during that investigation phase. I'm assuming that same thing applies in this case. If somebody's being investigated, a healthcare provider, they want to get an attorney, they want to get legal counsel, they don't want to try to fly blind. I'm assuming that applies here just as much, maybe more so because the stakes are so high.
I think it applies more so. And that's because these medical providers and professionals that decide to serve our country, there's a lot going on with regard to these investigations. And what do I mean by that? These investigations can encompass not just misconduct, they can also encompass standard of care issues. Okay. So the practitioner is going to be dealing with this investigation at that immediate command level. And yes, they absolutely should not handle it on their own. And medical providers, by and large, are highly educated folks. And with that comes a desire to try to figure this stuff out on their own. And that's a mistake. The folks who have hired us during the initiation of the quality assurance investigation that had our guidance from the beginning have earned a lot better results than the folks that handle the the QAI by themselves. They go make statements, they try to justify or explain themselves, and lo and behold, they only hurt themselves. And those folks face a lot more likelihood of seeing that peer review board on the back end rather than the folks who get lawyers who understand this stuff on the front end during the investigation.
You're not a psychologist for sure.
That's right.
But Why do you think they try to do that? Is it ego? Is it the intelligence factor? Why do you think they try to solve the issue themselves? Even though most of them, if you were to ask them, hey, I've got a problem, I've got an ailment, the first thing they would say is go see a professional, don't try to do it yourself. Why do you think they don't necessarily do that as often as they should?
I think it's an individual basis, and I think it's because if I'm going to talk about it broadly, I suppose I think it's because they're used to figuring things out themselves. They're used to solving problems. They're high functioning people, and they're going to want to solve this themselves to keep it as low level as they can, right? But what they don't realize is that if they don't get it right on the front end during the quality assurance investigation, their chances of getting it right on the back end become much more difficult. And the other thing you've got to realize too, Matt, is unfortunately the DHA PAM, which is DHA-PM 6025.13, unlike its predecessor, which is the PAM that I learned on, requires notice to the National Practitioner Data Bank if a summary suspension is in effect for more than 30 days. So what that means is that there's more at stake for these practitioners early on in the process than there used to be. And every practitioner who's going to listen to this and who hears, oh man, I might have to report to the National Practitioner Data Bank, that makes them very nervous. And so it's important to get good guidance on the front end. And what I mean by that is it's important to have guidance through the investigation and attorney. It's important to understand the themes and theory of a case, to actually have an intent when you meet with the investigator, if you're going to meet with the investigator. It's also important, Matt, to understand this might not be happening on an island. A lot of times our clients face not only a QAI investigation, they could also be facing a 15-6 at the same time. There could be other misconduct issues going on, like non-judicial punishment or actions for separation and all that kind of stuff. And that can be happening, believe it or not, that can be happening around the same time as the QAI. So there's a lot that goes into this.
Yeah, it sounds like the thing that you want to convey to folks who might be out there and dealing with this issue, God forbid, is that there could be much more to this thing than you can imagine. So even if you feel like, hey, I didn't make a mistake, or this relationship wasn't inappropriate, or I can explain this, there might be so much more behind the scenes that are happening during that investigation phase than they could ever imagine.
That's right. That's 100% right. They can get complicated quickly.
Yeah. Okay, well, anything else on the investigation? I think the next phase is kind of the review phase of it. Is there anything else on the investigation you think is important for the listeners to know?
So I want to talk about the investigating officer because I think that is important in QAI, because it's not just unlike with a 15-6 or a commander's inquiry where they apparently just pull anybody in to investigate anything. The investigating officer in a QAI is different. So the investigating officer normally must be a provider with similar experience and training, and they're appointed to investigate the allegations. Now, the investigation, as you said, is normally not limited to a specific case and may encompass a provider's entire practice of medicine or a sampling of the provider's entire practice of medicine, right? And the provider is no longer interviewed during the investigation, but is given a redacted copy of the investigation to provide comment. The investigation should include all enclosures, and the provider should be given access to relevant medical records. I bring all of that up for 2 points. Number one, the investigator is going to be somebody who knows typically this area of medicine. That's important. And then number two, if there are findings made by the investigator, the person being investigated has a right to the evidence and a right to comment. And that's the first real opportunity, in my opinion, to put forward a forceful defense. And that's got to be done right. It's got to be done legally right, and it's got to be done right from a medical standpoint. And if it's not done right, the chances of going to that peer review hearing are much higher.
So if somebody were to come to your firm, hire you for this, and you were putting together that response, which I agree with you, I think that's probably key, that initial response, because it is the first opportunity and a very significant one. At your firm, I would assume you would have folks working together on that, drafting it together, revising it, maybe even arguing points as to how much information should go into it versus what should be left out.
That's right. Our job is to conduct a thorough review of the evidence, break down the strengths and weaknesses for our client, make sure the client understands everything, because from a medical standpoint, your client's going to be your best your best witness. But if it's a misconduct allegation, like a sexual harassment allegation or something like that, they're not always going to understand, what is being actually alleged against them and what the facts are to support that. So we're going to want to outline the strengths and weaknesses, go through the evidence. We're going to want to conduct our own investigation if we think it's necessary, because it's not uncommon for important witnesses not to be interviewed. And then we're going to want to come up with a very specific plan of action, and being intentional about that response, having a plan of action, having a theme of theory of defense. That's what makes successful people successful and unsuccessful people unsuccessful in this process. And when I see folks handle this without legal help, they don't have intention. They're not specific. They don't have a plan of action except to, oh my God, I got to defend myself. And that's how people get in trouble. And so, it's vital to have legal guidance through this process.
Yeah, and you want more than one set of eyes, preferably, right? I mean, you might draft it up and think it's a masterpiece and think it's spot on. You might hand it to somebody in your office, like a Brad Simon or Mickey, and they say, well, wait a second, based on something I've done in the past, you might consider revising this or leaving it out or whatever, right? I mean, that team approach, it's not a sales pitch, but it's important. Team approach and having other professionals who have done similar things look at that can be key.
Absolutely. And it's not uncommon for us to also bring, my law partner, Robbie Morris, or attorney Amanda Dominic into these discussions as well, because we're one of the only firms in the country that practices military justice at a high level and also has a very robust VA disability team that consists of 2 attorneys, several assistants, and those folks deal with medical records and medical issues every single day of their lives. And so, we have a very unique background that allows us to provide really good guidance to our clients, because not only are we military justice attorneys, but we have a team that does nothing but work work disability claims, understanding medical terminology, understanding medical records that help us really put together our theme and theory of defense. So the last quality assurance peer review board that we were successful in it with our ultimate goal. And Robbie Morris and I did that together because he's got an expertise on the medical side, understanding medical documents and records. And of course, I had an expertise on litigation side and misconduct side. So I think we're very uniquely positioned to help practitioners in the service that are going through this process because of that background.
All right, so let's move on. I guess we've covered the investigation, then there's the review and kind of some decisions to be made about whether or not the case goes forward at that point, right?
Yeah, so essentially, if the privileging authority decides to move forward with a peer review hearing, that is exactly what it sounds like. That's a hearing to ascertain what happened and if the client is responsible for it. And Matt, it's important for these folks that are listening to this that might be under a QAI or facing a peer review hearing to understand their rights, because sometimes they don't. First and foremost, they have the right to counsel. They may address that counsel, and this is important, that counsel may address the peer review hearing panel and question witnesses. That counsel may conduct closing arguments. The pamphlet itself, the law doesn't say anything about opening statements, but in every one we've had, we provide opening statements. So really, they're very similar to separation boards. You're entitled to a full right to counsel who will handle this hearing for you. And that's very important to understand. You should not do that hearing by yourself. No matter what, you should not do the hearing without legal counsel. The second thing to understand is they have a right to present their case to a panel at that hearing. That panel will consist of a minimum of 3 voting privileged providers. So folks with similar backgrounds to the client who's being accused. A majority of the panel will be a peer of the healthcare provided under review with similar privileges, specialties, and experience. There are limitations on who can be in the panel, and that's laid out in the pamphlet itself. And the client, of course, may challenge any voting panel member for cause. There is some limited voir dire that happens. And then there is a non-voting legal advisor who represents the privileging authority, and they're not adversarial. So that makes it different than the normal separation board or BOI. That legal advisor, there is nobody there who is going to be arguing, in my experience, very little. These attorneys that are there, they're not really arguing that somebody should lose privileges. They're more there to facilitate a productive hearing. The legal advisor is there to make sure that the rules are being followed. So in the cases I've had, there'll be a lawyer or sometimes even a paralegal representative of the privileging authority, and then a legal advisor who often comes in from out of town. And the legal advisor is there to make sure it's a fair hearing, and then the privileging authority's representative is there to sort of help facilitate the panel's ability to hear witnesses and see the evidence. It's non-adversarial.
How much, in your experience on the ones that you've done, how much has that legal advisor contributed to the process? Is it very little? Is it a lot more than you thought?
I've seen great legal advisors. They're well-trained, and I've never had an issue with a legal advisor. There have been a few occasions where the privileging authority's representative wants to get adversarial, and it's not supposed to be that way. But that's only been on one or two occasions. By and large, they're just there to make sure the panel gets what they need to feel that they've had a fair look at everything.
And the makeup of the panel, it sounds like there might be some opportunity to change it or to alter it. But how important is it, the folks that are on there? I guess I heard you say they have to be folks with similar backgrounds and knowledge and expertise as the provider, who's being accused of doing something. But, how that can be, I guess, be a double-edged sword. You want somebody who relates to your person and understands the stressors that go in to practicing medicine or being a nurse in a military installation. But then also they may be holding that person to a very high standard as well. So what are your kind of general comments or specific comments about the panel themselves?
So minimum of 3 voting privilege providers. So all of the panel must have their own privileges to practice medicine. A majority, must work in healthcare with, similar privileges, specialties, and experience. So to your point, when it comes to specific, let's call it generically medical malpractice issues, which I've dealt with numerous times, in my most recent peer review board, there were some allegations that my client wasn't treating all the symptoms of the trainees that were coming to him. So, for example, a trainee would say, hey, I've got a bum knee and I've been getting migraines, and my client would just treat the migraines and not the bum knee. It was kind of a silly allegation. There were some other kind of generically medical malpractice issues. For example, another one that came up was that my client was not recording vital signs accurately, or he was asking his staff to change vital signs. And so those are typical, those are kind of your, not necessarily misconduct, it's more of your medical malpractice issues. And so having privileged providers look at that can actually be helpful to the lawyer, right? Because they're going to take a pretty active role. And if you call your client to make a statement, they're going to ask a lot of those questions.
Sure.
They're also going to know what questions to ask the witnesses, right? So it's incumbent on the lawyer to educate themselves on these topics, to be prepared for those topics. But yeah, Matt, they take a active role. It's not that dissimilar from going to a separation board where you have like a sergeant major on the board, and you call your client and he's going to want to know, hey, why did you do certain things? And they're going to ask you a little bit about your competency, about who you are as a professional. It's not really any different than that. It's very similar.
I was just going to ask you, you said you had mentioned a couple of times that these are similar to a separation board. Obviously, you've done tons of separation boards, and I would assume sometimes they come together as one, depending on what the ultimate result is. But, do you, maybe on a scale from 1 to 10, how similar do you think it is to a separation board, kind of the way that it's structured and the way it flows? The
biggest difference is it's non-adversarial. Separation boards have become absolute dogfights because there's nobody there to rein the prosecutor/recorders in. And that's just a fact. And
that's why you send the Blue Jay in there when needed.
Yeah, Dan Higgins is a wonderful attorney in these boards. But sometimes it turns into mayhem at the separation boards or BOIs. That's not the case in my experience with the peer review, because it's not adversarial, and everybody's
you keep saying it's not adversarial, but I would assume that your client thinks it's quite adversarial.
Yeah, well, it is litigation, right? Yeah. It does require theme and theory of defense, opening statements, closing arguments, cross-examinations of witness. My last peer review board, I think I cross-examined 12 people.
Really?
But there's no other lawyer attacking you.
Yeah.
Right? There's no other lawyer
There's that void there,
right?
So there's
no the lawyer who is doing whatever they can to win their case. It really, my experience is the privileging authorities representative and the legal advisor are kind of just there to supervise the overall proceeding.
Yeah.
That's the biggest difference. Is it's just not quite as adversarial. I've had a few, hospital command legal reps that get a little weird at these boards, but by and large, it's not supposed to be that way.
And I guess we didn't talk much about this, but in terms of the duration of this, from accusation to through investigation, what typically do you see in terms of how long it takes to get to that hearing with the panel? Are we talking about weeks? Are we talking about months? Are we talking about a year?
This process can be very long.
Yeah.
This process can be very, very long. And in my experience, it takes a long time. It takes a long time to get a decision from the boards, and it takes a long time to get to, these peer review hearings. A much longer process, in my experience, than the typical separation board, and that's just because of the nuances to it all, right?
It's medicine,
right? And everything just seems to be going much, much slower than your traditional separation board. That's not a hard and fast rule, but that's been my experience thus far.
Understood. Okay, so are we ready to talk about the decision and kind of what happens at that point?
Yeah. So, the decision will be made. You'll get basically a statement of decision from the panel, and it lists out what is substantiated and what's not substantiated, and then it lists out whether or not the alleged misconduct had any impact on the safety of any patients. And then at the end of the document will be really the final recommendation, and that could be anything from revoke the privileges entirely to reinstate the privileges, but your client's got to be under supervision for a bit. And those are really kind of the two big ones, right? And there's others that are involved in that, but for purposes
like a
of
limitation on what they might do or who they might.
Correct. And the biggest thing is that you want your client to either get his privileges back or get them back with supervision, because then he or she doesn't have to report to the board of practitioners, right? There's no reporting requirements that come with that. So that national practitioners data bank that we talked about, if the privileges are reinstated completely or reinstated with basic monitoring, there does not have to be a report made to that. And for the practitioner themselves, that's key. That's a humongous deal. A big deal. If you get your privileges revoked, you've got to report it to the National Practitioners Data Bank, and that could lead to additional proceedings from that body that could lead to a revocation of your license to practice medicine.
Like in a specific state.
Exactly.
So now it's not just you can't practice at this military hospital anymore. You now can no longer practice at the state.
Correct. And, that's a big deal, right? Not much different than attorneys. If you get your license revoked, not only is that humiliating, but, you also lose your livelihood.
Yeah. We haven't talked much about this. We've kind of stuck to the nuts and bolts of this thing, but what is the mindset of, what has been the mindset of the clients that you've worked with that have trusted you on these issues to handle them? What's been their mindset? Are they distraught? Are they shocked? Are they confused by the process? Are they frustrated by it? I mean, maybe all the above. I don't know, but
all of the above, and scared, right? Because if it doesn't go their way, their career in the military is probably done, almost certainly done. But then also they may lose, like I said, they may lose that right to practice medicine. And when you're talking about a doctor, you're talking about somebody that has got 12 years of education to get to that point, your undergrad, your doctorate, and then all the residency stuff they have to do. So it's a big deal, Matt. And those hearings tend to be high intensity for the client, because they are facing a lot. And it's also, there's always the fear of the unknown, right? I mean, a panel of 3 people, you don't know who those people are going to be. You're very limited in your voir dire rights. That's scary. That would be scary for me as a lawyer, if I was facing an issue like that, right? So I would say fear, concern, and then, confusion, because the process takes longer than it should. It can have complexities to it. And most medical providers, they've never been in a courtroom environment in their lives. They don't understand it. We live in it every day. To us, it's common practice, but to them, to have to go in there and defend some of the decisions they made medically, that's a stressor for sure.
Yeah. Yeah. If they have a favorable result in the hearing and a favorable decision, is there any second bite at the apple? We've talked about in the past where you've represented service members on other misconduct, not medical professionals, and they might win or have charges dropped in a certain respect, but then the military then has kind of a backup plan for them, unfortunately, and takes some kind of adverse action against them. Is there anything that exists like that in this kind of medical setting or not so much?
I'll touch on that, but first, let's kind of go back to the findings, right? Because I think it's important to note a few things. So first, the findings and recommendations. The panel makes findings on each allegations and recommendation to the privileging authority, okay? The panel cannot deviate from the wording of the stated allegations or propose additional allegations. That's important because I've dealt with that before. And that comes up in boards too. The panel provides a written report with their rationale for all substantiated allegations. Okay. And then there's a requirement of a majority vote, and that vote is based upon the prevailing professional standards. That's what the recommendations and findings look like. If it does not go their way, then yes, they have the ability to appeal, okay, before the privileging authority makes final decision. And that's important to understand.
Okay.
And we handle those appeals as well. We've had several clients that call us on appeal. I can tell you right now, like any area of law, appeals are harder to win than getting it right on the front end.
I think we're getting near the end of this episode. It's been great. We obviously could dig into it. We could dig into all kinds of things about, prepping your client for what to expect at that hearing. And we probably could have 3 or 4 episodes on just this one topic, but we're going to wrap up this show. Let's do that with some recommendations that you have to either counsel who might represent somebody like this, or maybe more applicably to a medical professional who's going through it themselves.
Number one, and this is going to sound self-serving, but I mean it genuinely. First piece of advice is, as soon as you're placed under investigation, hire an attorney. And the conversations with that attorney should focus on things like, what is our theme and theory of defense? What are the strengths and weaknesses of the case? How do we exploit our strengths and mitigate our weaknesses? Those are the conversations that need to happen early on. Because if you're going to make a statement as part of the QAI, or you're going to provide comments as part of the QAI, that's going to have a significant impact on your attorney's ability to have maneuvering room if you go to a peer review hearing. So my first advice is hire an attorney and get it right and get it organized from the very beginning. My second piece of advice is this. If you end up at a peer review hearing, you need to have an attorney who is a skilled examiner, okay? Because the biggest tool you have for success is to examine the witnesses who are accusing you of misconduct. And that's where doing this on your own or going with a local military provider like a TDS attorney or an administrative attorney from a military base, that's where their inexperience is going to really hurt you, because cases are won and lost on cross-examination. So second piece of advice is make sure your attorney is a skilled cross-examiner. Ask them, hey, how many people have you cross-examined? What are some of your fundamental building blocks of a cross-examination? How do you handle witnesses who might know something more than you about a particular subject? Because that's important. In these settings, your attorney may be cross-examining another doctor. And that's a difficult thing to do.
Yes, it is.
So you've got to be ready. And so you've got to have an attorney who has examined experts. And ask them, how many experts have you cross-examined in your career? Because let me tell you right now, if you get that wrong, you're losing, okay? The third piece of advice that I would offer is, as long as you can afford it, you may want to consider bringing in your own personal expert, medical expert on your defense team. And that's important for two things. And I don't require this, but there's been several cases where I have required it. Okay, that does a couple things. Number one, it allows an outside observer with your background and experience to come in and say, okay, hey, client, I know you're emotionally involved in this, but it's not as bad as you think. Or, hey, what were you doing and thinking here? That is a wonderful way to really start to anticipate what the weaknesses and strengths of the case are. The other advantage that having your own expert helps you with is at the peer review board. It's somebody you can call. And we like to use a group of folks that were providers in the military that retired with benefits and honorable retirement and all that kind of stuff. And as long as their opinion of the case file is helpful, you call them and they get up there and they say, hey, I served 25 years. I was this and this and this in the military. I've been a provider. And they would then provide their independent opinion of the evidence. That can be very helpful. It can be pricey, but it can be very helpful. So
there's a lot at stake, though, in these cases.
A lot. I mean,
everything, really.
A lot at stake. And if they're not able to testify because maybe they don't agree with what you did, their ability to help us prepare for the cross-examinations that are coming and to address the case is really quite important.
It's kind of interesting in these podcasts that, you and the folks at your firm, they're very good at what they do. I think your results speak for themselves. And people, frankly, in the industry know the reputation of the lawyers at your firm. And I think you guys are very confident because of that. And you should be. That confidence is earned. But I always find it interesting to hear you talk about how you defer or you think it's so important to have experts and investigators on these kind of cases and others, because as good as you might think you are and your trial team at Capoville and Williams, there are people who know this stuff much better than you. And you're not afraid to bring them on board. In fact, I think you probably bring them on board more often than not. And they really do play a pivotal role in this process, right?
Absolutely. Matt, I'm a big believer of right people in right seats. And when we started Capoville and Williams, there were a lot of people that told me you could never build a military law firm with investigators and paralegals and legal assistants and attorneys that just write motions and attorneys that just do separation boards and attorneys that focus just on trial work. They told us from the beginning that such a firm could not be built for our service members. I disagreed with that. I still disagree with that. And we've done our best to build a team of people who have strengths in different areas. Because when somebody calls my office and they say, well, I'm talking to this other lawyer too. Typically that other lawyer in this line of work is a solo practitioner or maybe a guy or gal with a couple people. And I say, well, that's fine. But when you are playing a football game, you don't want your quarterback also being the lead blocker, do you? And you don't want your quarterback catching passes, and you don't want your quarterback tackling the opposing team's running back. And why do you think we do that? Because a guy like Tom Brady, who's very skilled in a particular area, probably isn't the guy you want playing linebacker in the NFL, right? I don't think it's any different when you build a legal team. You want the best litigators. You want the best motion writers. You want the best paralegals and the best investigators because you want to put your client in a position to be as successful as humanly possible. And oh, by the way, that's how the prosecutors do it. They have teams of people.
Yeah.
And you better be able to match that. So yeah, I've never been shy about, no matter the situation, our number one goal is to put our client in the best position possible. And if that means we have to bring in somebody outside like a medical expert, that's exactly what we're going to do. If that means I have to add a second member of my team to a case like a Robbie Morris or a Josh Conklin because of their sensational ability to investigate and to do legal research and to write, that's exactly what I'm going to do, even if it costs us money. And it does cost us money to put a lot of resources on these cases. But at the end of the day, it comes from a belief that our service members deserve great representation.
Well, it's a great episode. Anything that we've left out that you still want to cover? I mean, I think it's been a great episode. We've covered a lot. We could always dig into this stuff, and we probably will actually dig into some more of the specifics of each component of this process.
No, I mean, the only thing that I would say, I guess, to close it out is medical professionals have a close place in my heart. My father was a medical professional. My mom has been in the medical community for a long time. And so we are very proud of the work we do for our military service members that practice medicine. It's a unique area of law. It's a niche within a niche within a niche, right? But it's something that I think we're very, very good at. I think it's something we're very, very skilled at, and it's something that we take a lot of pride in.
Well, I think that's well said. And so we'll close out today's show. We thank our listeners for tuning in. Everybody, we will see you next time on the Military Justice Today podcast. Until then, take care and be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.